Hello all, this is D. Satyanarayana from Abhaya Hastham Foundation's Center for Legal Aid and Education. In this video, we will discuss about specializations a lawyer must gain once he has finished his law degree and he is enrolled as an advocate in a particular state's bar council. If you recall this clearly, in the last video we have said that we will have a separate discussion about a specialization. A lawyer must, specialize in a particular subject. You might have heard about, people saying that specific lawyer is a family lawyer, that particular lawyer is a civil lawyer, and there is another lawyer who is a criminal lawyer. How do you think these, prefixes join to the profession advocate? So normally there is a very long story. If you ask the people who might who might have an experience of, let's say, 10 or 20 years, they will tell you how they have come to know, with a particular prefix. That is, there is this person XYZ who is called as a criminal lawyer, who is a company lawyer, or a civil lawyer, or a family lawyer for that matter. Right. Let's begin with a general premise. You have completed your law degree, and then you have enrolled in a particular state's bar council. And then, from the moment you have enrolled yourself, the agency, the bar council, authorizes you to practice law in a particular state. Right? Now, how do you think the client base will approach you? Do you think simply because you have enrolled yourself as an advocate, that the clients will come thronging to you? No, that's not the case. You must establish your credentials in the legal service. You must have satisfied a series of clients so that the people whoever they have received remedy from you, they would go and tell others that we have a particular person, an advocate, who is highly effective in providing remedies to the approaching clients. Let's talk about specializations. I would classify, a method. There is a method, in my opinion, as to how one acquires specialization in a particular domain or a field in law. So here is what I call them as voluntary specialization and involuntary specialization. Let's look at what is meant by voluntary specialization. You are in your law degree, that is, you are undergoing your law degree, be it 5 years or 3 years law degree. When you have reached your midway, that is your midway to your degree, you would have loved a particular subject, let's say Constitution, for example, right? So you would read and read and read about the case laws, about the concepts, and then everything with respect to constitutional law. The moment you come out of your law school and that you have completed your law degree and you have enrolled as an advocate, and now that you're a constitutional expert, remember, because you have spent a lot of time reading about Constitution and the case laws pertaining to Constitution, etc. So that means, when compared to the others who have not read Constitution like you are having an edge over them, definitely, from the standpoint of practice, from the standpoint of practicing the constitutional law in high courts, right? So you have finished your law degree, and then compared to the all other subjects, you have read Constitution really well, and you have a considerable expertise, and you are lucky that the moment you have enrolled yourself, right, the first client that approaches you for remedy says that he has some problem with the interaction, with the transaction with the government, right? The client says that for the past 5 months he was not at home, but still he has received an EB bill of an exorbitant EB bill, let's say 50,000 rupees, whereas even at normal days when he used to be at home, the bill would just be 3,000 or so. So he was not there at home for 5 months and still he has received a bill of 50,000. Now, the electricity board, within the context of Tamil Nadu I'm talking, the electricity board is an instrumentality of the state. It's an agency of the state. Now, how do you seek remedy against the action or actions of a governmental agency? Right? You have lost your 50,000 rupees. Let's say if you don't pay your 50,000 rupees, maybe the electricity board would disconnect your electricity supply. So within a short span of time, you have to seek a legal remedy. Now you have a client who says that this is his problem, and then you need to rectify the situation. Now remember, you are a constitutional expert, and you want to launch a writ, right? Launch a case against the government, that is the government agency. So you go and file a petition in High Court and say that this is a problem, and then ultimately you provide a relief to your customer, and then the electricity board, the agency of the government retracts its bill and gives you the right bill. Now you have given the remedy to your customer, right? This is what we call it as voluntary specialization, meaning you have consciously spent a lot of your productive time on reading a particular subject, right? Particular subject, that is constitution in this case, and then you are fortunate enough to receive your initial clients who only have problems with governmental agencies, and then you take up their cases, and then you go to the courts and you provide remedy. Now this is very clean. You have no problems, right? So you have no problems in establishing yourself as a writ lawyer or as a constitutional lawyer. You may call yourself as. So this news will definitely spread across the society. The first client that has come to you and who has received a relief because of your actions, because of your legal prowess, etc., would go and talk about you that here is a man who is an advocate and who specializes in constitutional matters. If you have any problems with the governmental agency, you should definitely approach that person. Now this I call it as voluntary specialization. Voluntary specialization, meaning you have consciously taken a decision to master a particular subject, and you are lucky enough to receive a client who has a problem in a similar domain, and then you provide a relief, and then you go on to establish yourself as a constitutional lawyer. This is one part. Now, do you think we are lucky enough to have this kind of opportunity? Do you really think so? No. Let me give you another. Let's move on to the next classification. This is what I call it as involuntary specialization. Right? The first one what we saw was voluntary specialization. Now the second one we are looking at is involuntary specialization. Remember, you have spent most of your time in your college days, right, reading about intellectual property rights. I'm just giving you as an example. Okay, most of your time you spent in college reading intellectual property rights, the case laws related to the copyrights, the case laws related to patent disputes, right? You might have read in papers that there is a dispute between Vodafone, and then there is a Vodafone, or there is a dispute between let's say Samsung mapping. That's a famous dispute everybody knows, right? And then you hear that the faltering company, the faltering agency, has paid in millions of dollars as patent claims to the other party who has won the case, etc. And the advocate or the law firm that has argued in favor of the petitioner has earned in millions of dollars as a professional charge, etc. So you are excited about this financial opportunity, and then throughout your law degree, your time at law college, you have spent hours and hours together in reading the literature or reading the matters related to intellectual property rights, case laws. Then you went out of your way to listen to the lectures of all the experts in addition to the teachers in your college, right? Once you're out of the college, the same scenario repeats. You enroll yourself in a bar council of a particular state, and you walk out of the bar council. Now, you have spent around 6 months of your time in a belief that you will get a case that has something to do with intellectual property rights, right? So this I am talking about A person who intends to practice law independently. I am not talking about an advocate or a person who has completed his law degree and then goes on to work for salaried employment. I am not talking about him. I am talking about a person who intends to practice independently, who intends to practice law independently in various courts across the state. Now, you have enrolled yourself as an advocate, and for 6 months, you have no case that is related to IPR, right? You wait for some more time because you are financially supported by your family, you have other means of financial sustenance. So you wait for another 6 months, and it's been more than a year. There is not a single case you have that deals with IPR problems. Now, what would you do? Because you have to do something. You have finished your law degree and you wanted to practice law, but you have no clients for that area where you have spent a lot of time to gain expertise on that subject. Then what would you do? And one fine day, one person approaches you saying that there is a criminal matter. Police has illegally arrested one of his family member in a matter related to a crime. In reality, though that particular person's a family member has got nothing to do with the matter, and he comes to you for your assistance for a legal remedy, and he believes in you. He doesn't know, right? He only knows that you're an advocate. He doesn't know that you have spent a lot of time in intellectual property rights, and he doesn't know about your preference of dealing with IPR cases. He doesn't know all that. All he knows, he is a common man. All he knows that you are an advocate, and if there is a possibility that you may give him a remedy. That is all he knows. Now he comes to you, right? What will you do? Can you afford to tell that person who has approached you for a legal remedy in a criminal matter? Can you tell him that you do not know how to handle a criminal law, or you do not know how to handle a matter that is something to do with criminal law? Can you do it? It's a personal question. You should have to answer for yourself. Right? I may say, if you ask me that question, I would say no, I cannot say that. Because the purpose I have come into this profession is to practice law. I have an understanding on the basic rudimentaries of law, right? On the basic rudiments, my teachers have taught me how to approach any matter for that matter, be it a company law, criminal law, or civil law. So I have been taught the rudiments for which I have spent 3 years or 5 years together in a law school. Right? Now, that being the case, can I say that I do not know how to handle criminal law? No, I cannot say that. Now, each of you have to answer this question for yourself. I cannot answer for you. But if that question is posed to me, or that person has approached to me to provide a relief in a criminal matter, I would not say no. I would say yes. I will provide you the relief. Right? Now, let's hypothetically believe that you have taken up that matter, even though you have gained the expertise, even though you have the liking to practice intellectual property rights, you have still gone ahead and taken up this criminal matter simply because you had no case in over 1 year. Right? Now what would you do? You already know the basics of law, and then you have taken up the case, and then you started reading the facts, and then you have started to understand the matter, and then you have gone ahead and filed the bail, and you also managed to get the bail for that particular client, right? Now, for you to approach the court and get the bail, etc., it must have demanded some amount of your time in studying the facts and also studying the related law, and then also studying the procedure to approach a particular court, right? Now, what has happened here is the question, right? I call this as involuntary specialization. You are forced to practice criminal law in this case, and even though you have had your own doubts whether you will be able to successfully practice this or not, you still went ahead with the basic self-confidence that you already have certain knowledge about the law, and all you needed to do was some groundwork about the case, about the procedure, and you approached the court and you provided the remedy to your client. Now you got the bail, and in the eyes of that particular client who has approached you, now you have become a criminal lawyer, right? He doesn't care whether you have expertise in IPR or not. In his eyes, now you have become a criminal lawyer. Now, when he goes out and talks to other people, right? When he goes out and says that here is the person to whom I approached, right? That person has provided me the required relief. Now my family member is out on bail, right? Thanks to him. Now you have established yourself as a criminal lawyer, at least limited to that person's knowledge, right? Now he would go and tell others, and then that's how you become a criminal lawyer in the society, right? Do you realize now you have become a criminal lawyer, even though you didn't want to at the first time? Now you have become a criminal lawyer, like I've said, and this specialization you have acquired involuntarily. Still, it is a good thing, in my opinion, if you say so. Now that society itself has, conferred upon you a specialization, you must pick up that mantle and move ahead with that particular specialization, leaving behind the other specialization you wanted to practice. Now, this is to your advantage. Let's say down the line, 2 years or 3 years later, if someone accidentally lands at your office for a remedy, with respect to IPR laws, you would still be able to do it. You would still be able to provide remedy to your client because you have long ago voluntarily acquired expertise on that particular subject. Still, you will have an edge over the others, right? That's the best thing. So nothing goes waste. The time you have spent, in studying a particular subject, the time you have spent in understanding particular concepts of a particular domain in law is definitely valuable. Nothing goes in vain, right? The time you have spent in understanding particular concept and the mental bent you have created for yourself by spending long hours in reading will definitely come in handy while practicing in courts, while reading lengthy briefs, while reading new case laws for a particular issue, etc. Nothing goes in vain. Be it involuntary or voluntary, if you do not spend your time in reading, you will not be able to practice law successfully in the courts. Believe this, and this is for sure. There is a general understanding that advocates, they have a preference in spending a lot of time outside courts, in police stations, and they have this tendency to settle matters outside the court by engaging in different negotiations and trying to provide remedy to the clients. But in the long run, this will not help you garner a good name in the eyes of members in the society. As an advocate, you must be ready at all times to practice before courts, to practice before judges. That is where you show your legal prowess and then provide remedy to your clients. Not outside the courts, not outside the legal institutions, etc., where you argue, outside the boundaries of law and settle matters. That is not what an advocate should be doing. Though there is a separate section or a separate creed of lawyers who believe that that is the best thing to do. In my opinion, it is not. The first requirement for a specialization in a particular domain is to gain a depth in particular subject. Right? If you want to practice a criminal law, I'm just talking about this as an example. You must master the procedure. You must master the CRPC, the procedural law. You must master the IPC. You must master the evidence. And you must also master all the case laws that are related to a particular offense or particular crime, for that matter. Without mastering these areas, you cannot call yourself as a criminal lawyer, right? So, having a depth in a particular specified area is very important, right? This is not to say that you should ignore other areas in the law, right? Now that I have said that you should master in CRPC and in IPC and evidence, etc., this is not to say that you should not read Constitution and understand its important concepts, right? That is where you develop the breadth. So in criminal law, you develop the depth, and in other allied matters, you develop the breadth. Breadth and depth both are required, but the primary requirement is you must choose a particular field, be it voluntarily or involuntarily, and spend a lot of time in relating to the case laws and judgments and conceptual understandings you must have by reading different sayings of juries, etc. And then you must have a depth in that particular subject. One of my professors used to say that you should know more and more and more about less and less. This statement explains the importance of depth, right? If you want to claim yourself as a family lawyer in the society, you must have more and more about less and less. The less and less means the family law subject, right? Law is, it's a huge area, right? Ultimately, you cannot master every other subject in law. But if you want to have a specialization in a particular field, you must know more and more only about that family law, so that ultimately in the society you would be branded as a family lawyer, and then you can continue to provide remedy to people who have problems in that particular area. With this, we would conclude our discussion on how one should acquire specialization in a particular area in law, and then how to successfully practice that particular area of law. Thank you.